meeting number 67 of the House of Commons Standing Committee on Citizenship and Immigration. Before we get into our work for today, there is a quick matter for the committee to decide. On November 15th, 2022, the committee adopted a motion ordering the department to provide monthly data on the number of the people claiming asylum after entering Canada through non-official points of entry. Now that the committee has presented its report on the asylum seeker study and given that data are publicly available online, the department would like to know if it is still the will of the committee to receive these monthly reports. Okay, so the members would like to continue receiving the monthly reports.
Yes, Madam Chair.
Okay, Keelan, is that good? Okay. So now we will proceed to our clause-by-clause study of Bill S-245 and Act. Yes, Mr. Reddycop.
I have a question on scheduling, just a kind of a question. As you know, my colleague Tom Kimmich and myself have been dealing with this issue of the Indian students who were issued fraudulent college acceptance letters and by immigration consultants and are now facing deportation. I'm sure you've seen that in a motion that I put on notice for that. And I just also want you to know that I did a petition on this on Friday, and we've already got over 4,000 signatures on this, so it's definitely an issue that people care about. I heard through the grapevine that we might be scheduling something on this, and I'm just curious. I've just heard that there may be a meeting or something that we might do on this. Can you just advise if anything like that is happening?
Before we get on to any other study, we have a legislation before the committee. We have to complete this because we cannot get any further extension. We have already taken that extension. So I don't know how many meetings we will have on this. But first and foremost, we have to complete this, get back to the House, then we can proceed into any other business.
Okay, so there's no way that we can review that issue. You're not going to allow us to review that issue or talk about it?
We don't have time because the number of the meetings we already had, and because we already got a 30-day extension, and we will not be able to get any further extension. So we have to complete this before we proceed to anything else. Ms. Kwan?
Thank you very much, Madam Chair. Not to sort of belabor this point, but I think hopefully this will give some comfort to committee members and to the public. The issue around the 700 international students who've been mistreated by bad actors with ghost consultants, that's something that I wrote a letter to the minister early last week to call on the government to take action, especially with the need to state of deportations for these students and to find a permanent pathway for the students, whether it be a H&C application process or a regularization process. So that's something that I am working actively with the minister's office on, and hopeful that this would be addressed. So that's definitely a big concern for people, and rightfully so.
Thank you, Mr. Dhaliwal.
Madam Chair, I would like to thank Mr. Kimmich and Mr. Reddycop for bringing this issue forward. It's a very important issue to the government on this side as well. As Madam Kwan is in constant touch with the minister to resolve this matter, so do I on this side, and we want to see this matter, come forward at some point in time. The reason is that we do not want these bad actors to take advantage of these innocent people time and time again. And I'm sure on this side, Minister is paying attention to the victims, not to the culprits. And that's the plan, and that's what is happening right now. And I'm sure that in the coming days, and we will be able to see better results on this one. And as far as my understanding, I don't think it's even 700 students that we are talking about. But I think we should do is at some point in time we can have a briefing from the minister or the parliamentary secretary who's sitting along with us to see how many actual number are affected by this. And because every case is at a different level as well, right? And on the processing stage. So every case needs to pay attention because some of them might have already got approval and some of them are in the queue. But as far as I see, I don't think it's 700 people. But whatever number is, even if there is one, that is important that we should deal with it. As Madam Chair, you mentioned about the bill that we are doing right now, the citizenship bill. I ran into Senator Martin today, but I couldn't even say much besides good morning because we want to get this bill through this committee as well so it gets passed through the House and goes back and through the Senate and gets it all sent one day. And so she's very proud of bringing this forward, and we as committee members will as well. So thank you, Mr. Kmitch and Mr. Redikoff for bringing this forward.
Thank you, Mr. Dhaliwal. Mr. Redikoff?
With respect to Mr. Dhaliwal, the only thing I see the minister doing is sending tweets, and we need more action than that. So I think it's important that we deal with this here at committee as soon as we possibly can. I'm just wondering if Ms. Kwan said she sent a letter to the minister. Would it be possible for you to provide that to us? We haven't seen that, and I'd be curious. We sent a letter that I think was public, and so I'd love to see yours as well.
Thank you, Mr. Redikoff. Ms. Kwan?
Thank you, Madam Chair. I'm happy to provide that letter to the committee. That letter is on the public record, by the way, as well, as it is an open letter to the minister. Since that time, with that letter, I've also written a response to the minister's announcement to the fact that he is aware of the situation and that they would undertake to target the bad actors and not penalize the students. I've also issued a follow-up letter to the ministers, I should say, with respect to that, and I'm happy to table that as well. In essence here, what we do need action on is the staying of the deportation for those students that are impacted and a regularization pathway for permanent resident status or through an HNC application process. And so I'll be happy to table those documents for the committee.
Thank you. Mr. Dhaliwal?
Chair, I think this is enough for now, and let's move on to the important bill that we need to get it through as we have a deadline to meet.
Thank you. Okay, so we will now proceed to Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Today, pursuant to the order of reference of Wednesday, November 16, 2022, the committee will resume consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. We are continuing our clause-by-clause study of the bill. When we left off, we were on Clause 1. Ms. Kwan moved NDP 5. Madame Lalonde moved a sub-amendment, which was adopted. Madame Lalonde then moved a second sub-amendment. The floor is open for debate on the sub-amendment. Ms. Lalonde.
Very briefly, Madam Chair, and thank you very much, and welcome back to everyone. It's nice to see you all, and hopefully we can finish this very important bill that is in front of us. Just to clarify, and maybe an explanation about, to remember everyone regarding the sub-amendment that we brought forward, it was really to clarify that a child born since 2009 who received automatic citizenship due to the fact that their parents had the substantial connection is deemed to have been a citizen retroactively from the time of their birth, as opposed to only starting from when the bill comes into force. And this sub-amendments, colleagues, would also ensure that the new G1 category, which is the former Section 8, is correctly included wherever it would be in the amendment for consistency purposes. Merci.
Okay, seeing Mr. Redikoff.
Okay, so sorry, I got to get my head back into this from 2 weeks ago. And as you know, it's very complicated law. So I guess my question would be to the officials. Thank you for being here again and being so patient with us. Could you please give us your assessment of what this is doing?
Thank you, Madam Chair. So as was stated by the member, this is a technical amendment which is necessary to ensure that those who are becoming citizens through the provisions of this bill are considered citizens from the time of their birth. And that will also be consistent with how lost Canadians remedied by the previous legislative amendments in 2009 and 2015 were also remedied. Thank you.
Mr. Radikov?
So can you explain to us, if somebody, if it isn't done from birth, if it's done from a certain point, what's the implications of that? Why does this need to go back to birth?
Thank you for the question. The technical amendment is necessary to treat the extending of citizenship in an equitable way, in the same way that was done through previous legislative remedies in 2009 and 2015. And if the amendment is not done, then there would be a distinction, as the member mentioned. In that case, citizenship would only be extended from the time that this bill comes into force, if it passes, which means that citizenship would only be applicable for these individuals from that time moving forward. As to what the impacts would be, there may be some unintended impacts, and that's not necessarily desirable. Other than that, I will just ask my colleague from the Department of Justice whether there's anything she may wish to add on that front.
Thank you for the question. I think what I would just add perhaps is the framing of citizenship in the Citizenship Act currently, that we have citizenship by grant and citizenship by operation of law. And so generally with citizenship by operation of law, we're recognizing citizenship as a status that was acquired, sort of inherent to you as a person. And so I think there's something sort of conceptual there as well. That's all I'll add. Thank you.
So thank you. Is Ms. Scheindreich, is there an issue though with acquiring citizenship at a certain age, or is it just is the issue just to be consistent? Like I'm struggling to understand why it would matter if what matters, I guess, in my mind is from now forward, and so I'm just struggling to understand why the past is important there.
Yeah, on that specific question, I don't think I have anything to add. My colleague has given, I think, a fulsome response. Thank you.
Sorry. Thank you, Madam Chair. So I was just going to ask, this is dealing with cases of adoption, right? So the children going all the way back would be who have been adopted sort of by grant. They would have it by right, which means that if they had children born abroad, they would be able to pass on their citizenship. And my understanding is correctly? And this is the effect of the sub-amendment too, making that wholly within the amendment being proposed?
Madam Chair, just for a point of clarification, this amendment is actually applying only to the natural-born, second-generation born abroad children to a Canadian parent. It is not applying to adoptees. The adoptees are dealt with on a separate front and a different amendment. Thank you.
Has there ever been a comparative analysis done by the department then to examine citizenship policies and practices of other countries as we're going through this bill? This just came to me as we're going through this bill, trying to fix up changes the government has made 2015, 2009, back in the 70s. Has there been an analysis done of the practices of the United States or other countries that naturalize a lot of citizens of their own to see how we would compare to others?
Ms. Girard?
Madam Chair, when the first generation limit was put in place in 2009, my recollection is that we'd done some comparative work at that point in time to establish that when that change was made, as was previously discussed with this committee, that Canada's legislation from that point on would be more in line with the legislation of the UK and I believe Australia, who similarly have a first-generation limit. I think it's fair to say that based on the knowledge of the experts at this table, Canada's citizenship legislation is broadly in line with what we often term as the like-minded. So that's Canada, U.S., U.K., Australia, and New Zealand, where Canada and Australia and the U.K., as I mentioned, now have a first-generation limit, meaning that only the first generation born abroad are automatically citizens from birth as of right, as discussed in this committee. What's a bit unique to Canada is that we're not aware that those other jurisdictions, at least not in recent years, have done these kinds of legislative remedies that are backward-looking and restoring citizenship to what we've described as lost Canadians. And so that is more of a novel sort of approach and remedy that Canada has put in place. Thank you, Madam Chair.
Sorry, Madam Chair, just on the last part, can you just repeat that? I'm just trying to catch, what is it that we don't do? What is the novel thing that we are doing?
The thing that's novel is that in 2015 and in 2009, the legislative remedies that Canada put in place for lost Canadians were retroactive and restoring citizenship back to the date of birth, just as this technical amendment is proposing to do, and to recognize those individuals as though they had been citizens all along, as a policy remedy to this gap.
So then my question becomes so typically when these Citizenship Act amendments are done then in Australia and other jurisdictions, in your experience, does the Canadian legislation then, do we follow them or do they follow us? I guess who is setting the standard for the naturalization of citizens and how our Citizenship Acts work? Is there a model jurisdiction we follow, or are we the model jurisdictions that other places follow? And when looking at legislation like this, are we basically setting, because you just said it was novel, something different, are we then setting the standard for these other countries as legislation goes forward, or is it the reverse? Do we follow them?
Madam Chair, in the sense that Canada has taken a novel approach in remedying lost Canadians, I think it would be fair to say that Canada is setting a kind of a model for others to consider. There are at least 2 occasions where I've been invited to international expert fora to speak on this issue for that reason. Because legislation that's retroactive tends to be sort of more rare or less frequent, less frequently taken approach. But it has proven to be a good remedy and a good approach, and with the result that this committee is aware of in the past, through these remedies, we've been able to restore citizenship to just under 20,000 persons from those previous legislative initiatives. And this amendment that's under discussion now would similarly look to restore those benefiting retroactively for similar reasons. Thank you.
So, Madam Chair, just my question is, if the sub-amendment passes and an amendment passes, I've asked this question before, how many people would be eligible to regain their citizenship then?
Madam Chair, as I've stated previously in this committee, while we don't have a firm estimate, those benefiting from the legislative remedy to extend citizenship to the second generation and beyond, where the parent meets a connection, could benefit in the order of several thousand persons a year. But we don't estimate that. Well, we estimate that the number should be manageable in recognition, as previously discussed in this committee, that the department already receives in the range of 40 to 60,000 applications for proof of citizenship per year, and noting that the member put forward as well, some numbers in the low thousands, I believe, at the previous hearing. Thank you.
Those numbers were from a court case that was being given to us by a former Statistics Canada employee that was hired by, I think, the council in that case to produce some numbers. So I assume that they're all correct for the purposes of that court case. I was going to ask then, just on the administration of this section and how it's been done in the past, is this administered basically all digitally online now? Or is this a role where you have to go to an embassy overseas? I'm just wondering, like, is it all digital now, or is it partially paper, and therefore you need to go to an embassy?
Ms. Girard?
Madam Chair, could the member please repeat just the last part of the question, please?
Yeah, Madam Chair. So it's I'm just wondering, like, so on the administrative side, this passes, this becomes law, it receives royal assent. What, how would it work nowadays for you to apply to regain your citizenship? So if you believe yourself to be eligible, do you go online and you fill out a piece of a document all digitally on a portal, or is it a digital portal where you download a form, you fill it out, and then you go to a Canadian embassy or a high commission? I'm just kind of wondering, like, what does the process look like nowadays to do it?
Madam Chair, although a number of our applications are now increasingly being made available online, and the proof application is available through the website, my understanding is at this point in time, the application for a proof of citizenship is a paper form that it's currently done on paper, and it's sent into the department for processing. We are making improvements on the processing side all the time, but that is. And my colleague reminds me to let the committee know that e-applications are available for simpler cases. Thank you.
Excuse me. I apologize. I didn't want to interrupt our great public servant. But on a point of order, and I'm trying to find, and I understand the questions and how important it is to ask questions, but I would like to call a point of order on the relevance, Madam Chair, because this question has nothing to do with the sub-amendment, actually, that I'm bringing forward. And maybe on the sub-amendment, as I brought clarification, and even before about the numbers, this sub-amendment would not change anything in numbers. So I just want to make sure, Madam Chair, through you, that we see relevancy on the sub-amendment questions that we're asking, which is very legitimate that my esteemed colleagues is asking questions to understand the complexity of everything. But I think my colleague is asking about processes that have no bearing on this sub-amendment, Madam Chair.
Thank you, Ms. Lalonde. Just one minute.
On the same point of order, Madam Chair, when you have a moment.
Yeah, just one. I'll go to Mr. Kimmich and then we come back. Yeah.
Thank you, Madam Chair. So the reason I ask these more administrative questions is because when you pass legislation, it has an impact on the civil service and how they administrate. I'm trying to understand what the impact would be on whether to vote yea on the sub-amendment or no, and I will ask on the main question then the same types of questions so I can better understand what the processing times would be like. Because you're talking about adding another 20,000 people to the backlog. That is material impact. We pass legislation, civil servants then have to carry out the wishes of legislators, of Parliament, and it's material to exactly what's going on here. This is a complex piece of legislation when we literally have, like, the entire alphabet sometimes is noted in different paragraphs. I'm not a lawyer. I'm not burdened by legal education. I always say that. So I think it's valid to ask these types of questions so we can really understand what is going to be the impact on people and on civil servants who will spend their entire days having to process applications or to give an opinion when there's an application that is maybe right on the line of what the intent of Parliament was. So I think it's completely relevant. But thank you, PMO, for sending that.
Thank you for raising your concern, like Ms. Lalonde and Mr. Kamich. I don't think so. It's an appropriate comment which you made in the end. But these types of things should not be brought. We are going through a legislation, considering clause by clause. So let's try to stay on that, focus on that, and let's get this done within our deadline. So, Ms. Gerard, would you like to comment on a?
Sorry, nothing to add, Madam Chair.
Thank you, Mr. Kamich.
Thank you, Madam Chair. So just to go back then, I actually was pretty much over. I just wanted to understand the impact on the department. So if the impact on the department is you have a process right now, correct? If the sub-amendment passes with the amendment, not an impact that you're not unfamiliar with, you have a paper system right now. So is this one of the ones that's going to be digitized in the future? And then my next question was going to be if right now there is a process by which you can try to regain your citizenship, or there will be a process by which you can regain your citizenship. You can prove you have one parent, move to two parents. All of that will be done in the current, how long would it take to implement this? Is this an easy change, or is this something that would take perhaps a year or two to implement?
Madam Chair, in my experience having coordinated all the implementation preparations for the 2009 legislative amendments to restore citizenship to lost Canadians, as well as the changes in 2015, I can say with confidence that the preparations generally take a year, because you normally have IT changes to facilitate the processing of the new types of cases that the department needs to facilitate using existing processes, as the member mentioned, but still IT changes are required. And there are generally always some regulatory changes that are required, and the regulatory process takes a minimum of a year, and the IT changes generally as well. And then many other changes are done in parallel to support those two processes in terms of any changes to policy guidelines, training for officers, communications with members of the public who are benefiting, and so on and so forth. Thank you.
My last one. Are there dedicated personnel in the department that only handle this? I know there are so many different immigration streams, but are there dedicated civil service department that only look at files about regaining citizenship?
Madam Chair, there are dedicated personnel in the department who handle citizenship-related applications, and that could be grants, it can be proofs, can be standard proofs, it can be citizenship being restored type proofs. So yes, there are dedicated personnel.
Thank you, Madam Chair. I just wanted to do a follow-up question. You had mentioned about when you were talking about other countries and how this was a novel process. My question there's two questions really. One is maybe more of a curiosity, but do you work together with other countries sometimes? Do you communicate with each other, share best practices, things like that? But my real question there is there any issues if Canada has a different process versus other countries, or is it completely irrelevant that way?
Madam Chair, there are regular exchanges of information, but I wouldn't say necessarily that we wouldn't work with other countries on changes such as this, because our responsibility as public servants is loyal implementation, and so we take that on, and we're well organized to do that. I wouldn't either say that it creates any issues for Canada to have a somewhat different approach. Every country has its issues that it needs to contend with. But it definitely can be a point of interest for those other countries in terms of what solutions Canada has been able to implement and what has been the positive result. And I have had occasion to share that internationally with Migration 5 countries and much broader group of citizenship experts internationally who have taken an interest in Canada's legislation and approach on this issue.
Seeing no further debate, we will go for a vote on the sub-amendment by Ms. Lalonde. Mr. Clerk, if you can please take the vote.
Mr. Ali,
Yes.
Mr. Dhaliwal, Mr. El Khoury,
Yes, oui.
Madame Kayabaga,
Pour.
Madame Lalonde,
Oui.
Mr. Kimich,
No.
Mr. McGuire,
No.
Mr. Redekop,
No.
Mr. Aitchison,
No.
Mr. Brunel-Duceppe,
Oui.
Ms. Kwan.
Yes.
Yeas 7, nays 4.
The sub-amendment is adopted, so now we are on NDP 5 as amended. Seeing Mr. Redekop.
Okay, so on this one, we already had demonstrated some confusion about whether this involved adoption or not. So I think I really need to understand, first of all, what this amendment is trying to do, and then I have more questions. So maybe if the officials, if you would share with me from your perspective what this amendment is actually going to do, how it's going to change, what problem it's trying to solve, and all of that. Thank you.
Thank you, Madam Chair. If I can briefly summarize, so it is not dealing with the circumstance of adoptees. It is dealing with the circumstance of the natural-born children born abroad in the second generation or beyond. And so the first element is, in terms of the sub-amendments, is it's bringing a transitional amendment that's necessary to ensure that for those benefiting where they may have been granted citizenship at some time in the past because the law wasn't considering them citizens as of right, that the grant of citizenship is considered never to have happened, as we discussed at the last hearing, and they are considered citizens as of right from their birth. So it's undoing the transitional sub-amendment is necessary to undo the effects of that previous grant, and that is in line with legislative remedies from 2009 and 2015. And the second sub-amendment is more of a technical provision ensuring that all of those who are becoming citizens through this provision because their parent meets a connection test are considered citizens from their birth and not from the coming into force date of the amendments, should they pass. Thank you.
So one of the questions asked was, what problem are we trying to solve here? And so I'm still not clear on that.
Madam Chair, these are, as I've mentioned before, transitional and technical amendments which are necessary to bring these legislative remedies in line with previous legislative remedies from 2009 and 2015, and to address the issue of equity and treatment for those benefiting from these legislative provisions with those who have benefited from the past legislative amendments from 2009 and 2015, so that those benefiting can be considered to have been citizens from the time of their birth, regardless if they were previously granted citizenship, and where persons are becoming citizens because their parents meet a connection, that they are also considered citizens from birth and not from the time that the legislation comes into force.
Okay, so if I understand, then we're not creating a new type of way to get citizenship here. We're just correcting some inconsistencies and problems from prior legislation. So
correct.
This doesn't actually impact, for example, some of the amendments or things that we've already done so far in this legislation. This is all related to past legislation. Is that am I understanding that correctly?
Yes, it's bringing the remedies into line with those past legislative remedies. That's correct.
Okay, so and this will then impact, will this impact, like we did an amendment that put in a test of, I think it was, I don't know if it was NDP, whatever, a previous amendment that we did. Does this affect that one as well then, or does it have no impact? You're going to ask me for which one I'm talking about. I think I'm talking about NDP 3, yeah, or G3 maybe. G3. Just a minute. NDP 3 maybe? Sorry. Yeah, NDP 3, that's the one.
Yes, Madam Chair. So that's correct. This is a transitional and a technical provision that's necessary to enable the department to properly and smoothly implement NDP 3. That is correct.
I think I'm good.
Seeing no further debate, we will go for a vote on NDP 5 as amended. So, Mr. Clerk, if you can please take the vote.
Mr. Ali,
Yes.
Mr. Dhaliwal. Yes. Monsieur El Khoury,
Yes.
Madame Kayabaga,
Pour.
Madame Lalonde,
Pour.
Mr. Kimmich,
Contre.
Mr. McGuire,
Against?
Mr. Redekop,
No.
Mr. Aitchison,
Opposed.
Monsieur Brunet-Duceppe,
Oui.
Ms. Kwan.
Yes.
Yeas are 7, nays 4.
We will, so NDP 5 as amended is adopted. Now NDP 6, Ms. Kwan, would you like to move that?
Thank you very much, Madam Chair. NDP 6 deals with what I would loosely term as the war dead, and that is to say those who went to war and fought for Canada, however, not recognized as Canadians, and many of them actually died in the battlefield. So I thought it was important symbolically to recognize them in that sense. The changes would actually have no derivative effects for Canada whatsoever. But that said, I understand that this will not be supported, but it was just important for me to put it on the record in any event.
So I guess straight to the officials. I'd like to hear your thoughts on this amendment.
Thank you for the question, Madam Chair. In line with some concerns shared with this committee with regard to an amendment previously tabled that would have benefited persons who passed away, there are a few concerns for the committee's consideration. The first being that we cannot estimate the number, the potential thousands of persons whom this proposed amendment may extend to. The second, as noted before, is that there is no precedent for this in the sense that up until this point in time, legislative remedies for lost Canadians have only extended to the living. And so that brings to the third concern shared with the committee before, in that there could be unintended consequences. And it's difficult to know ahead of time what that may be because there's no precedent for this. One area the department can point to, as previously noted, is the potential for unintended consequences on the citizenship by descent of the persons who would be benefiting from this provision who are alive today. There is a kind of a safety valve a clause that the member has mentioned. But we're not convinced as the department that safety valve in terms of avoiding consequence on the citizenship by descent of the living is ironclad, and so that concern remains. So those are the four issues for the committee's consideration, and I'll pass it to my colleague from the Department of Justice, who, in case she has anything she wishes to add.
Madam Chair, I would just reiterate my previous comments from our last session, which is to say that it's open to Parliament to legislate retroactively, but it's inherently complex because you're talking about a law currently applying to facts in the past. So it can be difficult to predict the effects of that, particularly in a case where you're looking at facts quite far in the past, so 80 years. Thank you.
Ms. Girard referred to I can't remember the word you used, but the clause that you felt was there to try to protect Canada from having unintended consequences that you felt was not adequate. Which part of the amendment is that?
Ms. Girard?
Madam Chair, if the question was about the previous amendment, which was somewhat similar to this one, I believe it was NDP 4.
Sorry, that's...
Mr. Can you please repeat?
Madam Chair, I understood the question to be which previous amendment was raising these kinds of concerns, and that was NDP 4. Thank you.
Sorry, I think that Mr. Reddycobb had something different.
Yeah, sorry, I think I confused you. On this amendment, you had mentioned that Ms. Kwan had put a part into this amendment to alleviate your concern, or to try to alleviate the unintended consequences on potential for future descendants or things like that. And I'm just curious what part of this amendment was that. Does that make sense?
Yes, Madam Chair, I'm just borrowing the binder of my colleague here. If I read section 8.1, it begins, for any period before the day on which subsection 7.1 first takes effect, with respect to a person, subsection 7.1 does not have the effect of conferring any rights, powers, or privileges, or imposing any obligations, duties, or liabilities under...
Point d'ordre, Madame la Présidente. Point d'ordre.
May I point of order? Madam Chair? Yes, just for clarification purposes, the interpreters are asking that are we reading the amendment or are we reading the actual bill, just so they can interpret it? Yes, we're reading the amendment. Very good, interpreters.
Merci.
I think
Thank you.
reading is complete.
So you were reading the amendment? Yes, Mr. Brunel,
À ce moment-là, Madame la Présidente,
In that case, Madam Chair, we'll have to reread it for those listening to us, for people listening to us on TV or on the web. They need the interpretation.
Thank you, Madam Chair. I would direct the members to provisions 8.2 and 8.3. 8.2 is rather short, and it refers to no person has a right to citizenship as a result of any other person being deemed under Section 7.1 to have been a citizen, and 8.3 refers to no action or other proceeding for damages may be brought against His Majesty and right of Canada or any officers, employees, or agents of His Majesty, and so on. Thank you.
Ms. Girard, Mr. Reddycobb?
Thank you for that. Okay, I'm a little scared because I actually understand kind of what 8.2 and 8.3 say. They make sense to me. But now you're saying that is probably not good enough from a legal standpoint. So I guess I'm kind of curious why that wouldn't be sufficient.
Ms. Girard?
Madam Chair, I will just repeat my observation that a provision like this, while helpful, is not necessarily ironclad and hasn't been tested, and so we don't know the result. Thank you.
Thank you, Ms. Girard. Mr. Reddycobb?
So in other words, it might sound good, but until it's been tested in court, we don't really know. And lawyers have a way of doing amazing things, right? Okay. I think that's it for the moment. Did you have some questions?
Okay, Mr. Kimmich.
just again a comparison point for the other countries that naturalize a lot of citizens, like Australia and the United Kingdom. Do they have provisions like this of any sort? I guess the United Kingdom is aside because they have a very similar system. Our problems, I guess, kind of stem from not having adopted our own Citizenship Act pre-1947. But in the case of Australia, have they done something like this, similar, or have they just kind of carried on with different models of their own Citizenship Act?
Madam Chair, I'm not aware that Australia has any such provision, and the sort of the point of comparison relates to a previous point that my Department of Justice colleague made, which is that generally citizenship legislation provisions apply to the living. And this is an amendment which is dealing with persons who have passed away. Thank you.
Gerard? Seeing no further debate, we will go for a vote on NDP 6. If I can ask the clerk to, Mr. McGuire.
In regards to the timing of this comes up to the original part of it here. The 7.1 is to bring it up to the date. They weren't citizens if unless they passed away. If they had been alive the day this comes into effect, they would have been deemed to have been Canadian citizens right back to birth. That's the correction of it. And I should know this, but what was the time frame of the vacancy in there? If they were in their 20s at this particular time, was there a limitation when they would have been, or where was the gap involved?
Madam Chair, this is dealing with those who passed away sometime between 1867 and 1947. And the first Citizenship Act came into force on the 1st of January 1947. And so it's dealing with persons who passed away before that time and who, had they been alive subsequently, would have become citizens, but for their death. Thank you.
Thank you. Good. So we will go for a vote. Mr. Clerk, if you can take the vote on NDP 6. We are voting on NDP 6.
Mr. Ali?
No.
Mr. Dhaliwal? No. Mr. El Khoury?
No.
Madame Kayabaga?
No.
Madame Lalonde?
No.
Mr. Kimich?
No.
Mr. McGuire?
No.
Mr. Redikoff?
No.
Mr. Aitchison?
No.
Mr. Brunet-Duceppe?
Oui.
Ms. Kwan?
Yes.
Yeas 2, nays 9.
NDP 6 is defeated. So we will, just to let everyone know that NDP 7 cannot be moved because of the fact that NDP 2 was defeated. So with that now, we complete Clause 1. So shall Clause 1 as amended be carried? Is everyone okay with that? Clause 1 as amended be carried? Yes, Mr. Kimich.
Without revealing which clause 1.1 is a different clause, right? Sorry, I don't have the original piece of legislation. I only have them by amendment. Okay, so
We will be going into the next is 1.1. So
perfect. Okay.
Yeah, we are like,
wanna make sure.
this is Clause 1.
Okay, perfect.
We will proceed to Clause 1.1 after that.
Okay.
Okay, so is everyone okay? Okay, so Clause 1 as amended.
Just do a recorded division, Madam Chair.
Okay.
Thank you.
Okay, so I will ask the clerk to please take the vote. We are voting on Clause 1 as amended.
Mr. Ali?
Yes.
Mr. Dhaliwal? Yes. Mr. El Khoury?
Yes.
Madame Kayabaga?
Oui.
Madame Lalonde?
Oui.
Mr. Kimmich,
No.
Mr. McGuire,
No.
Mr. Redekop,
No.
Mr. Aitchison. No. Mr. Brunet-Duceppe,
Oui.
Ms. Kwan.
Yes.
Yeas 7, nays 4.
Is carried. Now we will proceed to the new clause 1.1, NDP 8. Ms. Kwan, would you like to move it?
Thank you very much, Madam Chair. I actually have a new NDP 8 to move, Madam Chair, and the new NDP 8 essentially collapses all the sub-amendments, the 3 sub-amendments from the government side into the one. So that new NDP 8 has been shared with the clerk for distribution, and I will just quickly talk a little bit about what that does. Effectively, NDP 8 ensures that the new connections test is also being able to apply for children adopted from abroad, and also addresses what happens if the child is born before the death of the parent who must meet the connections test. How this new NDP 8 would be different from the previous one, it does remove the grandparents' component piece. So this is different in that sense that it.
Thing is the new NDP 8 which you are moving, is it in regards to the document reference 124567999?
Yes, 124567999.
Yeah. Okay. That's good. Thank you. You can
Yeah.
proceed. Yes, Mr. Redekop.
Is this being sent around to us?
Yeah, that's what I wanted to confirm before it is sent out, that which one she is saying.
Okay, can maybe we just pause for a second until we have
Let
it?
her read first, and then we
Okay.
will go into. Ms. Kwan, you can go ahead.
So, and I'll read this onto the record so people know what I'm talking about. But essentially, it brings forward all the changes. I guess maybe this is a better way of saying it. Brings forward all the changes that we talked about earlier around the connections test and the application for parents, but applying it to adopted children as well. That's essentially what this does. So the new NDP 8 will read as follows: that that Bill S245 be amended by adding after line 18 on page 1 the following new clauses. 1.1 subsection 4.2 of the Act is replaced by the following: 2. For the purposes of paragraph 3.1b, subsection 3.2, and paragraphs 3.3a.01 and c, if a child is born after the death of either of their parents, the child shall be deemed to have been born before the death of that child. 1.21, paragraph 5.14a of the Act is replaced by the following: A, if at the time of their adoption, I, only one of the adoptive parents was a citizen, and that parent was a citizen under paragraph 3.1b, C.1, E, G, G.1, H, O, P, Q, or R, or both of the adoptive parents were citizens under any of those paragraphs. And 2, neither of the adoptive parents was a citizen who had a substantial connection with Canada. 2, paragraph 5.14b of the Act is replaced by the following: B, if at any time only one of the adoptive parents was a citizen and that parent was a citizen under any of the provisions referred to in subparagraphs 3.3b I to Roman numeral 8, so VII, or both of the adoptive parents were citizens under any of those provisions, and at the time of the adoption, neither of the adoptive parents was a citizen who had a substantial connections with Canada. So effectively, this brings all the changes that have been passed previously on the connections test and its application for parents to adoptive children as well. In the ideal universe, Madam Chair, I would have liked to have grandparents to apply it here, but I know that that is not the will of the majority of the committee, and so I'm not going to be able to get that through, and I have accepted defeat, and therefore I'm moving this amendment, Madam Chair.
Thanks a lot, Ms. Kwan. Thanks a lot, Ms. Kwan. Because this has to be distributed to all the members, I would suggest that we suspend the meeting for a few minutes so that the clerk can distribute this to all the members. Members can have a look, and then we come back. Okay? So the meeting is suspended. the NDP 8 has been new NDP 8 has been circulated to all the members. So we have new clause 1.1 NDP 8 on the floor. Mr. Reddycop.
Thanks, Madam Chair. Actually, I have a quick point of order just to say that we have a CPC amendment coming after this one, but before NDP 9. So I just want to make sure that we get the chance to raise that one before we move on to NDP 9 after we're done with this one.
We have NDP 8 on the floor. Any discussion? Mr. Reddycop.
Yes. Okay. So I guess first question over to the officials. Tell us your thoughts on the implications of this, and if this is worded correctly, if there's unintended consequences, etc. Oh, actually, just before I do that, I just want to say that I think the adoption piece, which is what we're talking about now, is important to all of us, I think, and I think us on this side as well are interested in finding a way to fix this problem that's been in this legislation for a while. It's one thing that I think all of us have gotten a lot of contacts, letters, emails, and conversations about, so it is something that we want to fix, but as always, we want to make sure that it's done correctly and that we don't create any further unintended consequences. So please share your thoughts on what's proposed here.
Thank you, Madam Chair. As stated, this amendment is important for equity to extend citizenship also to international adoptees who are being adopted in the second generation and beyond by a Canadian who is themselves a first-generation Canadian born abroad. And, the department is also aware of concerns of parents of international adoptees who are looking for a direct route to citizenship, such as this one, where a connection test is met as an alternative to going through the immigration process and the sponsorship route where families are affected by the first-generation limit. So this remedy would be beneficial and helpful from that perspective. Thank you. And there are not any concerns about unintended consequences.
Mr. Reddycop.
Thanks. Maybe for our benefit and for the benefit of maybe some of those watching, could you give us an example or two of how this would actually work now in practice, and maybe point out where the problems are today and how this would fix that problem with an example or maybe a couple of examples?
Madam Chair, so the issue today is if your parent is born in Canada or naturalized in Canada and chooses to adopt internationally, there is direct access to citizenship. But where the Canadian parent is already first generation born abroad, so it's the grandparent who is born in Canada or naturalized in Canada, parents are affected by the first generation limit, just as they are where their child is naturally born abroad in the second generation or beyond. And so what this amendment is doing is providing a direct access to citizenship in those circumstances where one Canadian parent is able to meet that same connection test, as was previously discussed. And so it provides an important remedy that's being sought to address those concerns. Thank you.
Thank you. And so this, I guess what I'm trying to understand now is when Ms. Kwan said that she had backed away from some things in here, I think with grandparents, she said, can you explain that a little bit? What was originally intended by her, like as far as the grandparents, and what is not happening?
Just before we go to Ms. Gerard, Mr. Dhaliwal, you were saying.
Thank you, Madam Chair. Madam Chair, this is a very thoughtful.
We have to get a response. Are you?
Yeah, that's what I'm gonna
okay,
ask
so
a question.
we'll have Ms. Gerard first, and then come to you, Ms. Gerard.
Madam Chair, if the question is about why grandparents are not included, it's for consistency with the previous amendments and approach with regard to extending citizenship to the natural-born kids of Canadians in the second generation and beyond. For those, it's where the parent meets the connection test, and so here through this measure, making that same avenue available for international adoptees, again, it would be for the consistency where the parent meets the connection test.
Okay, thank you. Mr. Dhaliwal?
Thank you, Madam Chair. Madam Chair, my question to the officials will be, if this is true today, where because this is a very thoughtful revision that Madam Kwan is bringing in, for the purpose of paragraph 3, brackets 1, bracket B, subsection 3, bracket 2, and the paragraph 3, brackets 3A-01 and bracket C, if a child is born after the death of either of their parents, the child shall be deemed to have been born before the death of that parent. I think this is an excellent addition, because I have seen, Madam Chair, day after day. I mean, there are cases come to our constituency office where people have married spouses, who were citizen here, and their spouses now, because their relationship doesn't exist after the death, and they're not allowed to come in here. In fact, this is important for the children. I would like to know if that factor is still today is effective or not.
I'm sorry, Madam Chair. Could the member just repeat the last part of the question?
So the question is, thank you, Madam Chair. The question is, this clause amendment that Madam Kwan is trying to bring in, this is not possible today under the Act.
Madam Chair, that's correct. There is no access to citizenship for international adoptees where it's a case that it's the second generation born abroad or beyond.
Mr. Dhaliwal?
Fine.
Mr. Reddycop?
Thank you. So just on that paragraph, actually, that was the other one I was a little bit confused about. So can you explain to me what that paragraph 2 that Mr. Dhaliwal just read, what exactly that paragraph is doing?
Madam Chair, I'm going to ask my colleague to speak to that point. Thank you.
Thank you, Madam Chair. So this provision that you're asking about is specifically related to where a child is deemed to have been born before the death of that parent. So we'll ensure that today someone who would benefit and is getting citizenship under this bill, if they have, if they were born before the death of that parent, that we will recognize as if the parent was born at the time of their birth. So they will get access to citizenship, and they don't need a living parent at the time they come forward and apply for citizenship. We will look at their parent's substantial connection, even if they're not living at the time that they come forward. And this is consistent with previous legislative changes in 2009 and 2015, so that they can use their parents' substantial connection to become a citizen automatically.
Thank you, Ms. Bernard. Mr. Reddycop and then Mr. Dhaliwal.
Okay, so just to make sure I understand what you said, so a parent adopts a child, a child, the adoption is in process, and then the parents die. Is that the scenario that we're talking about? Because I'm still a little bit confused about exactly how this would apply and who this would apply to. Maybe an example, if you could give me an example.
It would apply in that scenario, and it's not only for adoptees. So it would also be the case of natural-born children to Canadians, or, as you just mentioned, an example where there is an adoption and the parent dies during the adoption process or something unfortunate like that. So in both instances.
So then, and the reason why it's written this way, the child shall have deemed to be born before, is just to match the wording of the legalese in other cases. Is that a fair assessment?
That's correct.
Madam Chair, I'm going to simplify this because I'm trying to clear in my mind the question that I have. Let today, forget about this bill 245, S245. Today, the parents adopt a child, and the parent that adopted a child, some reason, unfortunately, died. So then that relationship does not exist now because that child would not be able to come. As I said, there are many spousal cases where, they get married, and because the spouse dies, that relationship goes away. And so, is that true? How would it address those cases? Yeah.
Yes, Madam Chair, I think we just need to clarify the question whether the member is referring to the current state of affairs or under the bill.
Current state of affairs, like today, if that is the case, how does that affect that adopted child if both parents, let me say that there's one parent or both parents, if both parents are citizen, then both dies. If there's one that was citizen that dies, what happens to that child that's adopted in present circumstances?
I'll ask my colleague to answer.
Thank you, Madam Chair. I believe, if I understand the question correctly, you're asking if under the current legislation, if a Canadian parent or two Canadian parents seek to adopt a child internationally and then become deceased prior to the finalization of that adoption, under the current legislation, the adoption cannot be finalized since deceased persons cannot adopt children.
So would it rectify that situation under this bill?
Thank you. It is my understanding that even this bill would not be able to rectify the situation of someone who is deceased and therefore cannot adopt a child. A child cannot be adopted by a deceased person.
Let me say the adoption goes through, right? Adoption, the eligibility for adoption passes, because there's many other formalities that happen. We have seen in many cases where the spousal case, right? The eligibility of the spousal marriage case goes through, but the spouse does not get a visa, and the spouse that sponsors from Canada dies, so then that the sponsor, even though the eligibility is passed, would not be able to come. So in that particular instance, if the adoption is cleared but the child is not on Canada land or doesn't land in Canada, would that rectify that situation?
Ms. Duan? Thank you, Madam Chair. Again, as I understand it, in order for an adoption to be finalized, an international adoption to be finalized, there has to be a genuine parent-child relationship that is established. If the child then receives citizenship because they have a Canadian parent who either is in the first generation and meets the substantial connection requirement or is already a Canadian citizen who is able to pass on citizenship, if the parent then dies following the adoption, that does not sever the adoption. So the adoption would stand, the child's citizenship would stand.
Thank you, Mr. Khan. Mr. Daliwa? Okay, now
Thank you.
McGuire.
Thank you, Madam Chair, and I thank my colleague, Mr. Dollywell, for the question that he was asking, and who follows up a little bit with my colleague, Mr. Redekop, here as well. In regards to that timing, I follow exactly what you're saying, Mr. Wan, in regards to going to have one or both parents at least alive, or that adoption isn't going to take place, even though it might have been in the process. I guess I'm going back to talk about what I was asking in the earlier question in the other clause that we had today, and whether there's any impact of what period of time are we talking about, in what years does this take place, or is it any of time previous to where we're at today?
Yes, Madam Chair, thank you for the question. This would be with regard to, similar to the natural-born children who are benefiting from the connection test, where the Canadian parent meets a connection test. This is similarly benefiting international adoptees from since 2009, from the time the first generation limit was put in place in 2009.
Mr. Redekop wanted to ask something before I went in because it was a follow-up.
Mr. Redekop.
Thanks. So just thanks to Mr. Dollywell for asking that question, because it's part of my original confusion on this. So just because I was under the impression that this is on the question of an adoption and the parents die, because in this paragraph 2 we're talking about an unborn child whose parents die. That child obviously comes into the world and has to have citizenship. So that's the case from what I understand. But what you're saying with, if in the same sense, if an adoption is in process but the parents die, then the adoption does not continue on. So it's different than in the case of a birth. Am I understanding that correctly?
Ms. Girard.
I'll ask my colleague to speak to that, Madam Chair.
Thank you, Madam Chair. Yes, I believe that your understanding is correct. Although I believe every attempt is being made to equalize the treatment of the natural-born children of Canadian citizens abroad and the international adoption of children by Canadian citizens abroad, the mechanisms are slightly different, the circumstances are slightly different, and as a result, there are going to be some differences in how the legislation needs to apply to different circumstances. Thank you.
Mr. Redekop.
So then, is this creating an unintended consequence, or it's just a difference between that needs to still be dealt with, or is this the correct way to deal with it, I guess would be the question.
Madam Chair, thank you for the question. I would repeat that there are not any unintended consequences from the perspectives of the expert at this table. This is an amendment which is an equity measure that's necessary to extend citizenship to international adoptees of a Canadian parent in the second generation and beyond, just like the natural-born children that have been discussed before. That's there's nothing further to add, Madam Chair. Thank you.
I understand, but is that not creating an inequity? If you're pregnant and you're bringing a child into this world, that child will become a citizen should you die. But if you're doing the exact same process but through adoption, you're trying to bring a child into this world, so to speak, and you die, then that child is never going to be a Canadian. They're going to end up back where they started. Is that not an inequity?
Ms. Girard.
Madam Chair, the proposed amendment is seeking to minimize differences between the natural-born and adopted children of a Canadian parent as much as is legally possible. So it's not creating new distinctions. However, there will be a big distinction and a big inequity should this amendment not go forward to equalize things as much as is possible legally between the natural-born and adopted children of a Canadian parent. Thank you.
Mr. Reddycop?
So are you saying then, first of all, there is a bit of an inequity here. Would you agree that if it's a natural born child versus a child going through adoption, the outcome is different? So that is, however small or big you want to classify it as, but it is an inequity. Is that a fair statement?
Madam Chair, I'm not stating that there is an inequity for the record. What I'm saying is that this amendment is necessary in order to create equity as much as is possible between the adopted child of a Canadian and the natural-born child of a Canadian, so that both, in both circumstances, there can be access to the connection test. And so far in this bill, we've only dealt with the natural-born children of Canadians. Thank you.
So is there a legal way to fulfill that, to complete that equity where an adopted child whose parents die in the process could still become a Canadian citizen? Is there a legal way to do
that? We believe that the proposed amendment is doing that insofar as that is possible, while still respecting a number of obligations that Canada has when international adoptions come into play, to ensure that the proper diligence and safeguards are in place. And those include the elements that the adoption has to be in the best interest of the child. As my colleague has mentioned, the adoption has to create a genuine parent-child relationship. And thirdly, the adoption has to be in accordance with the laws of the place where the adoption of the adopting country and the country of residence and the country of residence. Thank you.
So are you saying then that if a child is in the process of being adopted, the parents die, that according to the rules of other countries, that adoption could not continue? Is that what you're saying in those words? Or is it something that could we just say, change the legislation to say that adoption can proceed, and then the normal course of action happens as if the parents had died in the same equitable way?
Thank you, Madam Chair. I believe that because Canada is party to a number of international instruments with relation to international adoptions that are designed to protect the welfare of children, and as my colleague mentioned, those three primary pieces, the genuine parent-child relationship, etc., it is not possible for there to be a genuine parent-child relationship in cases where there is no parent. In those cases, the adoption would not be able to proceed, and as such, the adoption would not meet the legal requirements under Canadian legislation or the international agreements to be able to proceed. So it is not a case that Canada is acquiescing to other countries' requirements. These are requirements that are built into Canadian legislation to protect the well-being of children being adopted internationally. Thank you.
Okay, I think I understand. And I get what you're saying, that you're taking this as far as you possibly can without crossing that line that you just described, Ms. Dewan. So is that fair?
That's correct.
Okay, now we can.
Thank you, Madam Chair. Just to go to this new NDP 8 amendment.
Okay, sorry to interrupt. Bells are ringing. Vote has been called.
So we can either ask.
Do I have the unanimous consent to continue? No. So the meeting is suspended. So if the bells will be 30 minutes. Are the bells 30 minutes or 15? 30. The bells are 30 minutes. We have the resources available until 6 o'clock. So we will not be able to come back. So the meeting will have to be adjourned.
But is this a quorum, maybe? Should we ask? What is it? Like?
No, it has to be unanimous. It has to be unanimous.
No. Is it a vote or a quorum? I will just check. Just wait one.
I just want to. Sorry, we don't know. So we don't know. It
can be a quorum call too, like.
think they did. Okay, so it's them.
So it's 30 minutes bells. It's a dilatory motion. That member may now be heard. So the meeting is adjourned. Thanks to the officials. Thanks for your patience. And thanks for coming back again. So we will come back to it on attention just before. So the meeting is adjourned. Now everyone can talk.